It's 1 o'clock.
Let's do it.
All right.
Wait for it to say live, and then you should be ready to go.
All right. Oh, it's on.
Here we go.
Okay. Welcome, everybody, to another episode of Ask the Expert with the Martin Eiden team. And we have our rotating guest interviewer, Whit Prouty, on today. And Whit is going to talk with Ben Nachemson about bankruptcy, which is a hot topic with this roller coaster of a year. So, Whit, take it away.
Thank you very much, Martin. Appreciate it. Yes. So today's guest is Ben Nachemson of Wolf and Nachemson. Ben is a bankruptcy attorney, and we're going to talk about all the interesting things that are going on because of COVID and our economy and what the heck is happening out there. Ben, welcome.
Thank you.
And can you tell us a little bit about yourself?
Well, I've been practicing bankruptcy through two recessions, and it looks like it's going to be my third one here. Out of UCLA Law, I externed for a bankruptcy judge. I've been through, since 1990, for 30 years. I started out with a boutique bankruptcy firm doing Chapter 11s, did Chapter 7 trustee work, then was on my own, creditor work, really Bank of America. And then for the last 10 years, I joined up with some other lawyers. We have a great little practice. I do the bankruptcy end, and I've seen it all. So then this is going to be an interesting cycle.
Fantastic!
Interesting.
Wow. I think we're all just kind of holding our breath because of what's going on with the economic circumstances driven by COVID. Can you tell us, as a bankruptcy attorney, are you busier than ever?
Yes and no.
Okay.
It's a very interesting cycle because of what the government did to slow down the pain. The large companies, they can look ahead and they can see what's going on, and they file the bankruptcies in Delaware. I'm somewhat involved in the Hertz bankruptcy. But that doesn't really affect the local market. The local market, and what we're really going to talk about today, homeowners, that's not starting out. And if you look at the year-to-year statistics, it's still down from last year, which is an amazing statistic.
Interesting.
The actual consumers who are filing bankruptcy is down from last year. And that's really because there's a moratorium on defaults. The government is not letting creditors evict people. It's not letting creditors foreclose. It's not letting creditors collect. Even the courts are all backed up. So there's a lot of people sitting on the fence. I have a lot of people called me and said, we're going to file, but the governor just extended my eviction moratorium another 3 months. So there's a wall, there's a wave coming, and we all know it's there. I've been busier and I've had those calls, but I think it's going to be something affecting a lot of people in the next year and maybe two.
Do you have, so you think it's like a year out to possibly 2 years out? It's going to be that far of a drag?
I meant to say that the process is going to be a year. I think it's going to be starting much sooner. I think the day in California, the governor says, okay, evictions can go straight forward. I think things will start. I have a case right now with the United States Marshal, and we're holding off on acting just because the United States Marshal said we could evict, but we don't want to. And there's some bureaucrat who's just making the decision not to start coming down on people.
A bureaucrat with a heart.
I don't know. Maybe it's a federal bureaucrat. So there's a moratorium on evictions, and I think another key issue in bankruptcy, and I put this to my clients, is it's not just stopping your debt; it's moving forward. So especially in the business world, and we can talk about that. But in the business world, if you don't know where you are, where you can start, revenue can start picking up, you're really kind of frozen. And until we get a little bit of a break from all this, and we really know what the revenue is and how much debt you can pay back, then things can really start to move forward. So I think all those things are keeping bankruptcy a little bit at bay, but still, there's a lot of people suffering out there, and I have been busier.
So tying that in then to what we do, I've heard of this thing called a homestead exemption. So talk to us about what it is and how bankruptcy how they interplay.
Well, this is a California phenomenon, and it's
Okay.
something to California, and it really doesn't have to do with COVID. It actually has to do with with the legislature just changing the law. January 1st, there's going to be a new law, and it's going to say that for a homestead exemption, it's going to be the countywide median sales price for a single-family residence up to $600,000. So what does that mean? The median sales price for a single-family residence in Los Angeles County is $664,000. So LA County, it's $600,000. Riverside is $400,000. San Bernardino is $370,000. But anywhere close to the coast, you've hit that cap. And just to give you an idea, today, if you're single, it's $50,000. If you're married, it's $100,000. If you're a senior or a low-income person, it's $175,000.
Okay, so what does that mean?
Yeah. Okay, so what does a homestead exemption mean? It means if you file bankruptcy, or if somebody wants to come and foreclose on your property, a judgment creditor, somebody has a judgment against you. If you have equity in your property that's more than a homestead exemption, then your house will get sold in bankruptcy. So people will call me and say, I have no money. And what about where you live? Oh, it's this little shack in LA. It's just worth like $1.2 million. And I say, and what's the mortgage? Oh, $800,000. You can't file bankruptcy, because if you file bankruptcy, you lose your house. And today that person's going to call me, same conversation, but I say, if you can hold out till January 1st, you can file bankruptcy. You can file bankruptcy and you can walk away from all your debt, and you're going to have a ton of equity left in your house. And you can borrow against that equity after the bankruptcy. It's really a game changer in terms of
Interesting.
in terms of your options in filing for bankruptcy.
Okay, so let me ask you this question then. So obviously in LA County, we have a median sales price that is actually approaching 700,000. We're actually keep going, even through COVID, we're on the rise with our median. We're above the 600,000. But say that you have equity which is greater than 600,000. What happens?
At that point, if you want to file bankruptcy, there's a risk that the house would go for sale. That's not the end of the equation. Another big equation, especially in California, is capital gains, because in California, since your basis is when you bought the house, if you've held the house for a long period of time, no one's going to sell it without paying taxes. So if you wanted to, let's just say, for instance, my example, there's a $1.2 million house and you had $500,000 in liens and there was $700,000 in equity. If a trustee would have to still pay out $200,000 because they bought the house in 1980, that's not going to happen. So you can still file bankruptcy and you'll still be protected. Another calculation that has to be done is the cost of sale. 6 to 8% is where you start playing with. And if you still take out 6%, then the trustee can't sell it. You can go to court and say, after you take out the taxes and after you take out the cost of sale, there's nothing left for creditors. So, judge, you can't let anybody sell the house.
So you are driving down that range, that equity cost, so that you can get below the 600,000.
Yeah, 600,000. Okay, that's really interesting.
And I want to say something really interesting. If they do sell the house, and what happens if you sell the house? When you sell the house, 600,000 will go back into your bank account. So whoever, let's say there are liens, and there are tons of liens, involuntary liens, I have to say, people with judgments against you. They'll get paid whatever they get paid, and you'll collect your $600,000. Now, here's the kicker in California. In California, you have to take that $600,000 and in 6 months buy a new house.
Okay.
Because if you take that money and you don't use it to purchase a new house, then 6 months later, they can come back to you and say, "Oh, we want that $600,000 back."
Wow.
Okay. Interesting. So do you know then how lenders are looking at that? Are you able, is there a moratorium then? Or,
Lenders are voluntary, they have voluntary liens. So I don't think this really affects the lending world too much. The homestead exemption is really what happens is if you file Chapter 7, this is what I would do for you if you walked into my office and you had all these liens on your title report, and you looked at your Chase home mortgage, you looked at your equity, and it went above the value of the house. You file a motion in bankruptcy court. You say to the judge, wipe all these liens off my title report, and wipe all these liens off, make an order, say they're all gone. They'll all be gone, and then those debts are also gone in the bankruptcy themselves. So it really is something that will affect you if you have debtors with judgments. When debtors file judgments, a good creditor attorney, creditors may have judgments. A good creditor attorney is going to file an abstract of judgment, and it's going to be sitting there on your property. So with this homestead exemption, I really have a lot more tools in my in my armory to help people, because I got $600,000 where I used to have $150,000.
This truly makes it really attractive for homeownership in California, in as far as protecting assets is concerned. Correct?
I'll tell you a story. If you were back in the day, if you were a Hall of Fame running back and you didn't go to jail, but you had a big wrongful death, judgment against you, where would you move to? You would have moved to Florida, because Florida never had a homestead exemption. So if you have debts and you want to buy a house and you're afraid that people are going to come after you, California all of a sudden is looking a lot more attractive than Florida or Texas or New York. It's a good place. It's a good place to come, and you're protected. You have a $600,000 cushion in your house that no one can touch. And that's
an interesting,
something to be interested in.
Okay, so I've got a client, let's say they've got liens against their residence. How do you help them?
Well, like I said, so one thing that people walk into bankruptcy.
Can I just back up for a second?
Yeah, sure, Martin.
What type of liens would be against the property other than like the contractor not getting paid or a tax lien? Is there other types of liens?
Well, there's two types that come into my mind, Martin.
Okay.
One is just somebody you owed money to. They went to court. They got a judgment against you in some contract dispute, any contract dispute, and then they would go and file with the court their judgment. So there's a lien. The other one that I see most of the time, I think, is individuals have companies and they guarantee loans on their companies. So that guarantee is going to be protected. That usually it's a Small Business Administration more often than not, and they're going to have a lien on your house.
Got it.
So those are the two types of liens. That's voluntary, to be quite honest. That's not as easy to get rid of. But the judgment lien is what we're talking about. And that's what a homestead is about, protecting your assets. You buy a house. If you have money, buy a house. Don't rent, because you'll take that money and you'll have a house and you'll have $600,000 that no one can touch.
Wow.
That's great. Okay, so let's say you want to buy a house from someone in bankruptcy. What are the things that we need to do? What do we need? What are the pitfalls? What do we need to guard against? All of that kind of good stuff.
Okay, so what usually happens in a regular type of sale that you're going to do with is you're going to draft your documents and you're going to put pending bankruptcy court approval. That means you're going to enter escrow, but it's not going to close unless the bankruptcy court says it's going to close.
So we have to go before a judge.
Before a judge. So what has to happen is that the person selling the house has to go into bankruptcy court and say, you know, which client is willing to pay $2 million for this house? Does anybody want to pay more for it? And Whit and I have been through this process. People are going to get noticed through various means of the sale, and people will walk in the court and will say increments of 50,000. Does anybody want to pay $2,050,000? If someone might get up, you have the ability to raise your bid at $2,100,000, and the final person with the highest bid is going to get the house. One thing when I was talking about this with Whit, what a bankruptcy lawyer needs to do is, if you buy the house and the judge orders the sale, usually the person selling the house is running all the documents, and he does a fairly decent job. But one thing he won't do for the buyer is say that the buyer is a good faith purchaser, because that doesn't interest him. And why that's important, and this is a bankruptcy thing, is you buy the house and the person who you outbid with is not happy. If he sits and files a notice of appeal, that sale can't close unless you have that in the order. And I've seen a lot of times just no one thought of it and it's not in the order, and all of a sudden you have a sale. It wasn't residential, it was commercial, but the sale's held up. So so make sure you have a lawyer at least that knows that has to be in there, because that gets overlooked all of the time. But otherwise,
Interesting.
Yeah, but otherwise that's really the process. It's going to be run by the trustee. And there's a lot of deals to be made, you know, buying distressed assets.
Yeah, like you said, we actually have worked together and sold homes. And I will say part of the process too is it's very interesting, because the person that you go into that first escrow with is not necessarily the person that is going to end up with the property. Even though they do their due diligence, there's money held in the escrow, it is all subject to bankruptcy court approval. And once you get that date and you go to court, there can be other people that show up, and then they can outbid you. So for a buyer, if you really want the property, it's very important for that buyer to show up in court to protect their purchase. And our last purchase, our last sale that Ben and I did, it was a duplex, and lo and behold, people did show up. The price got bid up, and it got bid up significantly from the number that we originally went into quote unquote escrow with. So very important to protect that asset. And it really doesn't matter that you spent money on inspections and all that kind of stuff. At the end of the day, it's who is the best buyer for the property as decided by the judge. Correct, Ben?
Yeah, I'll tell you, in these type of cases, what's my most powerful weapon? Because distressed assets, what people in bankruptcy don't realize, that a distressed asset is a distressed asset. So they will walk into the bankruptcy saying, oh, I know this house that sold for this much money. And, you know, whatever reason it was, you're only allowed to put the house on the market and take the best bid after a short period of time. You can't say to the court, oh, I didn't get the bid I wanted, give us another 6 months. You can't do that. And a lot of debtors have that. They don't want to give it up. And what happens, and this happens to me a lot, is it's really the broker I come to rely upon, saying, listen, you know, if they don't sell the house, it's going to foreclose, and foreclosure price is going to be a lot lower than the bankruptcy sale price. And I know it's not what you want, but there's a bidding procedure, and it's really the distressed asset. And I always say, in bankruptcy, the value of the price is the best offer you get in that time period. So they have a concept of fair market value that is not really realistic. And I found my most successful bankruptcies in this area is when I have somebody like Whit helping me out, you know, being the person to push them, but represent them. because that's a problem with a bankruptcy lawyer and probably all lawyers. We want to advocate, we want to do what our client wishes, but what if our client's wishes are not exactly what we think is the best, is the best thing to do?
Interesting.
So
Right.
that happens a lot.
So on those bankruptcy sales, do you have to show up with a cashier's check of 10% of the purchase price, similar to a foreclosure, or how does that work? Well,
you need to put down a good faith deposit and a non-refundable deposit. An interesting, this usually doesn't happen in your basic sales, but if you're really helping the trustee out, I was in the sale when a person, there were issues with the house and he came up with an all cash offer. You could actually ask the court to be reimbursed I called stalking horse fee, like 3%, or anywhere between 3 and 10% of the sale price. That's a little bit unusual. I didn't think I was going to go into that because I'm talking about just your basic sales. But in your basic sales, you walk in, you have the financing. What is interesting is before the sale date happens, you send out a notice saying that if you want to show up, we have to qualify you as a bidder, and you have to come. You have to come about like a week before the hearing and just show us that you have the ability to make the bid that you're going to make. So it's not like somebody can come at the court and say, "Oh, I want to spend $2.3 million." You have to call me first, and you have to. I'm this in this world. I'm either the trustee, attorney, or the Chapter 11 debtor. You have to call me first, and you have to show me your financing and your ability to make the bid. So that protects everybody, that we don't have people coming in and making bids that they can never consummate. And the final thing is there's something called a backup bidder. So even if you're not the final person who wins the bidding process, you'll go to the court and say, I want this person to be the backup bidder, so that if anything fails with the top bid, the number 2 bid is locked in, at least for two weeks or a month or whatever, that we can go back to them and we can lock them in their bid that failed because the first bid fell out.
So that brings up a good point. If you do then secure a backup bidder, then hopefully, and am I correct here, that then you don't have to go back before the judge to move on to that buyer.
Well, that's the point of the backup bidder,
right?
Because we all know that somebody's going to make a bid and somebody's going to want to pull out. So we have somebody in our back pocket. We don't have to. The court has granted all the authority to the agent, to the seller, to move forward with the sale without going back to court.
Right. So you have a court-approved backup, which is real important to not having then scheduled to get back into court and before the judge.
Yeah, I've never been through a sale that had to go back and redo it because people fell out. Between all the protections of showing you have the ability to make the bid, and by the way, I think all these, if you have the cash, these are usually going to be good deals for the bidder.
Got it.
So it's not something I've seen fall apart as long as it's done correctly.
Okay, so I just happen to know this. I've heard about this. What is Subchapter 5, and how can it help homeowners?
Subchapter 5. This is another part of my practice. In February this year, there was a new law that was passed by Congress, and basically, I think a lot of people. Let's go back to that conversation I would have with that debtor. Like, you can't file Chapter 7, you have to sell your house. There was another type of bankruptcy called Chapter 13. Chapter 13 would allow you to take all the money that you owed your mortgager and allow you to repay it over a five-year plan. It's a great vehicle if you're in that situation where you just called me and you just can't file a Chapter 7, but there was one small problem in Chapter 13, especially in California. The debt limits were just a few $1 million, like $1.2 million, and the people would living in $3 million houses and $2 million houses. And they just had too much debt to be someone who could file Chapter 13. And I have to throw them out and say, I can't do Chapter 13, you owe too much debt. I can't do
Right.
Chapter 7. They passed what's called a Subchapter 5. And let me try not to skip anything. There's something called Chapter 11, which I'd be selling.
Right.
And this is what I work with WIT. I do a Chapter 11, but Chapter 11s are expensive. There's a lot of going to court. You have to go to court for just about every transaction you make. Individuals are just not very comfortable following all the paperwork. It's a lot. It's very good for a business with an accounting department, with a good legal budget. But for individuals, Chapter 11 is really hard, and a lot of them failed. So Congress knew this. So Congress did something to, we're going to make a Subchapter 5 of Chapter 11, which is an easier Chapter 11. And we're going to take out all the things that make Chapter 11 really, really difficult. And we're going to make it easier. I think as lawyers, we'll talk about all the little procedural things, but I'm going to make it simple that it made it much simpler, and it threw out so much, a disclosure statement, some prospectus that you have to file with the court, that you go to the court 5 different times to make sure everything was correct. They threw that out. So it's really a way to do a Chapter 11 for no one who can do a Chapter 13. What was fascinating, this is COVID related, is that when they first came out with it, they had about a $2 million cap on the $2.3 million cap on the amount of debt, which was kind of near Chapter 13, so it didn't really help me. When the CARES Act came and COVID came, they took the 2.3 and they upped it to $7.5 million.
Wow.
So any business, and this is really more important for business than homeowners, but any business with $7.5 million in debt, which is really all the small businesses, they have a much easier way to do bankruptcy. But for homeowners, and Martin, I was telling you about people with guarantees.
Right.
A lot of these homeowners are people who had businesses, and they're on a guarantee. And if you're on a guarantee, if the majority of the loans that are against your house, or the majority of your debt is based on you guarantee these business loans with the SBA, all of a sudden you're a small business. So
interesting.
So I think I haven't come across it yet. I've been dealing with a few people, but a lot of people who couldn't file Chapter 7, couldn't file Chapter 13. Chapter 11 was a daunting task. Subchapter 5 is going to be something really good. That's homeowners. You're going to hear a lot more about Subchapter 5, a little outside of this podcast, a little more with small businesses, but it has a lot of effect, and it's also a good tool for homeowners with business loans. And I mean, COVID is something that's bad, and of course it's going to make people file bankruptcy, but people should know that in the last year they've had these laws passed that are really helpful and are just really pro-debtor, pro having you file, get a fresh start, and walking away. And it's going to be exciting actually to be able to use these tools we never had before.
Which is exactly why somebody in financial trouble needs a professional like you, Ben.
Well, thank you.
Right.
Thank you.
Yes, absolutely.
You.
Protect those assets, right?
Right.
So we're getting down to the final minutes. Final question. I own a house. I'm getting married. What should I do?
Prenuptial. Because I think I've so much dealt with issues where just the divorce is what's driving the bankruptcy.
Interesting.
And a funny one is when one person wants to keep the house, but there's too many debts to pay. So you want to file bankruptcy to force the sale of the house. That's an interesting situation. I see it once every couple of years. It comes across my desk. California, because this is California's community property. I think a lot of people get married later in life. They have assets. You want to trust the person you're marrying, but they could have debts you don't know about. And I really think if you have assets, don't get that property into community property. Keep it separate. Because there was actually, and what was the catalyst for me and Whit talking about this is that there just was a new case where if you held the property as in a joint tenancy, as husband and wife, as joint tenants, then the courts were looking at it, even though you filed bankruptcy, they were looking at it as, two people having separate assets. The Ninth Circuit actually asked California Supreme Court, because it was based on the evidence code, which went against the family code. And the family code said everything you own is community property. The evidence code said, well, title says you own it as joint tenants, and joint tenants own property separately. So the evidence code and the family code were at war with one another. So the Ninth Circuit went to the Supreme Court, California Supreme Court, and said, hey, you have two laws that don't make sense if you read them together. Which one should we follow? And last year they said follow family law, saying that no matter how you hold the property, whatever way you hold the property, unless you really are specific to segregate the property, just saying you hold it as joint tenants doesn't take it out of the communal estate. So it's really
Making that prenup very important.
Without that prenup, and here's the prenup is actually under attack a little bit too. There was a scary case that said that even in a prenup, they look at the prenup to see whether you were fraudulently transferring property using the prenup. I think the case is wrong. I really do. But there were weird stories about that case because the prenup said, well, here are your judgments and liens. We're going to do a prenup and segregate your property. But if you get rid of the judgments and liens, this prenup is void. And the judges hated that. I think this is going to be my general rule. Even if you're following the law and you're protecting your assets, don't do something that so sickens the judge that they're going to come, that they're just not going to like you.
Wow.
I remember in that case, I was reading through that case, and somewhere in a deposition, the man who was owed these people money said, "Ha ha, I married a rich lady, but we got a prenup," and they even read that in the case. So
wow.
The moral of the story and the moral for bankruptcy is, I'm going to tell you about using bankruptcy to not pay your debts, but try not to do anything that's too upsets the conscience of the judges. That's
fantastic.
That's my little experience. You won't see that.
Thank you.
Law, but that's
Ben, thank you so much. I can't believe our half hour is up. It really does go so quickly.
Fast.
Completely.
Yeah, Ben, thank you so much. I really appreciate it. Go ahead,
back. Part two.
More evidence as to why owning a home is so important. So
nice
don't you love how things wrap up like that for us, Martin?
That's awesome. That's awesome, Whit.
Yes.
Well, thanks everybody. Again, Ben Nutcherson with Bankruptcy, and this is the Martin Eiden team with Ask the Expert. Next week is Sean Wilson, another guest host with the civil rights attorney. So I'm very excited for that. All right, guys. Thanks again.
Thank you guys so much. Really appreciate it, Ben. Take care.
Thanks.
Okay. Thanks so much.
Thank you.